Welcome, everyone. I am Jeff Lewis.
And I'm Tim Kowal. The California Appellate Law Podcast is a resource for trial and appellate attorneys. Both Jeff and I are appellate specialists, but we split our practices about evenly between trial and appellate courts. And in each episode, we try to give our listeners of trial and appellate attorneys some legal news and insights they can use in their practice.
And a quick thank you to our sponsor. Our podcast is sponsored by CaseText. CaseText is a legal research tool that harnesses AI and a lightning-fast interface to help lawyers find case authority fast. I've been a subscriber since 2019, and I highly endorse the service. Listeners of our podcast will receive a 25% lifetime discount available to them if they sign up at casetext.com/CALP. That's casetext.com/CALP.
Now, Jeff, way back in episode 42 of the podcast, I don't even know what episode we're on now. Who can count? So many episodes, so little time. Back in episode 42, we reported on the Victory Bell case. It was Garcia versus Quraishi, in which a successful defense counsel, Robert McKenna, bragged about his defense in a medical malpractice case. Do you remember this, Jeff? And the video depicted McKenna addressing his colleagues and staff, saying that the case involved, quote, a guy that was probably negligently killed, but we kind of made it look like other people did it, end quote.
Right.
And after that story came out, Jeff, I saw some commentators suggesting that the Victory Bell video, as it became known, was grounds for a new trial. And I kind of scoffed at that. And I saw some other appellate attorneys scoffing at that as well. But today's guest proved the naysayers wrong. Today, we welcome Brooke Bove, the appellate attorney who wrote the successful motion for a new trial in the Garcia Victory Bell case. Brooke focuses her appellate practice in catastrophic injury and mass torts cases. Before law school, Brooke served in the Army as a specialist translating and analyzing intelligence information, and she's fluent in both Arabic and French. Brooke took her Juris Doctorate degree, magna cum laude, from Whittier Law School in 2011, where she was a fellow at the Center for International and Comparative Law and a member of the Law Review. Welcome to the podcast, Brooke. Thanks for joining us.
That is probably the most amazing introduction I've ever been given. Thank you so much for having me.
No, you're very welcome. So you now that you're part of this big case in the public spotlight, obviously we had to reach out to you and I can say I knew you when. I knew you before you were the big successful attorney on the Victory Bell case. But before we explore that case further, I wanted to back up and talk a little bit about how you got into this spotlight. Tell us, Brooke, a little bit more about your practice. I think you're focusing in appellate law. Did you always focus in appellate practice?
No, I was a litigator for quite some time, 6 or 7 years probably, full time. Mostly in the personal injury realm, some elder abuse kind of cases, but always on the plaintiff side. And so I did that, but I was not satisfied, and my personality is not well suited to things like cross-examination and, fighting with opposing counsel over discovery deadlines and meeting and conferring stuff. I could do it in writing, but in person, like that confrontation stuff is not my favorite part of litigation. And I honestly get sometimes a little tired of the game that you have to play. And so I was feeling a little dissatisfied. Meanwhile, it was while I was at DeMarco Araujo, Montevideo, one of my colleagues tried a case and won, and the defense appealed it. And my boss was about to hire outside appellate counsel. And I said, hey, give me a shot. Let me do it. And he did. And it was great. And I really enjoyed it. And I was kind of bit from there on. And that was kind of the seed of appellate law. That was probably 2000. When was that? That was probably 2016 or something like that I did that. And then, now I have my own practice where I do focus on appeals. So I do appeals, and that's where I represent clients, is at the appellate level, but I also consult with trial attorneys regularly, where I get to where I do some like ghost brief writing and consulting about appellate issues and things like that with trial attorneys. So
right.
Those are kind of the two things I do.
And was your litigation practice focused in on personal injury cases?
Yes, and some elder abuse, which is of an offshoot of personal injury as well.
Right. And so in your appellate practice, is it mostly in the personal injury realm, or do you branch out from there?
I branch out. It's predominantly personal injury. I also do some employment law stuff. I've been getting more employment law appeals lately. And I've also done, some business litigation because the Code of Civil Procedure is applicable to everybody. So I've been doing some of that too.
What are the common issues that come up in a lot of your personal injury appeal cases?
Well, I guess probably I have two answers to that. One is lately it's been mostly summary judgment losses where plaintiffs lose a summary judgment motion. That has been really happening a lot lately. And anecdotally, I just think courts are just getting more and more comfortable with granting summary judgment. And so that's bringing up a lot more of those appeals. And we'll see if the Court of Appeals likes that trend or not. That I think that kind of started during the pandemic, the COVID pandemic. And now I'm starting to have the oral argument for those appeals on summary judgment. That's really starting to kind of happen. So that procedure of summary judgment and evidence that you put out in support of your motion or opposition and like all those kind of procedural issues related to summary judgment, that comes up a lot. And then if I'm speaking topic wise, I get a lot of Privet cases where, the Privet and Toland line of cases where it's, if you're the general contractor and you hire subcontractors to manage things going on, you're not considered the employer of the employees of your subcontractors. It's not like a chain of command where you get, sorry, I'm not explaining it. Let me back up. Privet is where if an employee is injured, his remedy is workers' comp, not by suing the general contractor of a work site or the homeowner of a home of a person who hired somebody to fix their roof or something like that. And it's a very detailed and a long line of cases about it. And I have quite a bit of experience in the Privet line of cases. So I kind of get those motions a lot. And so then that is what that happens and to be the subject of a lot of appeals.
Huh. Interesting. Hey, can I ask you from a business point of view, and don't tell me anything confidential about the Victory Bell case, but if you're doing a PI case on appeal, most PI cases are handled on a contingency basis by the trial lawyer. How do you end up getting paid as an appellate lawyer for PI cases?
It depends. That's a good lawyer answer, but sometimes the plaintiff will pay out of pocket for it. Sometimes sometimes the plaintiff attorney will just compensate me in the hopes that we win and that he gets paid back when and if the case goes to trial and he gets a settlement. But generally, so it's one of those two sources. Either the trial attorney pays me or the client pays me. And it depends on their retainer agreement. Most of the time, it's the trial attorney for the plaintiff who asks me for help. And depending on how they feel about their chances or how their retainer agreement is set up, or sometimes it's a hybrid. And I've also been asked, and I've done this only once or twice, but if I will do the appeal and then take a percent, become a partial do a fee sharing agreement where I then get a portion of the settlement when and if the case ever settles in the future.
Right. Interesting. Okay.
Now, Brooke, you were in the Army. You were a communications specialist. Tell us a little bit about how your path led down that road, and then how from there you came out on the other side as an attorney and eventually as an appellate lawyer.
Well, I grew up in a small town in Wyoming. It's actually not super small. It's one of the biggest towns in Wyoming, but it's still pretty small town. It's only maybe 18 to 20,000 people. And, there's one university in the whole state. And I was 18 and I was restless. I was like, there's a whole world out there. And I was in that sweet spot between where my parents were not going to be able to pay for my college. And they made too much money for me to get like a bunch of financial aid. So I didn't really know what I wanted to do. So I don't know. It was the mid 90s and it was a lot different decision, but I just said, screw it. I'm going to join the Army. I get to probably travel. And the Army recruiter wouldn't stop calling me. And generally I'm just a joiner by nature. So I was like, okay, fine. I'll try it out. What's the worst that could happen?
and what was the worst?
Nothing bad happened to me. I was in between 1996 and 2000. I was out before 9/11 happened, before there was any war. It was the time of my life. I met a million great people. I got to travel. I lived in Jordan for a summer. The Army taught me how to speak Arabic. They taught me, they gave me cultural training. They gave me all kinds of great training and interesting. I just met so many people. It was the greatest thing I could have ever done. First went to Monterey. I was stationed in Texas for a little while, and I lived in Georgia. And it was just a great way to get around the country and then also out of the country. And it was the best. So I'm so glad I did it. Then I got out and I decided I was working in the Army as a linguist and a translator and I don't know, part of my job that I was assigned to by luck of the draw was to work with the NSA on some projects. So I thought, hey, that sounds fun. When I got out, I tried to apply for the NSA and for the FBI and a few different places. And they were just like, go get a degree. We don't want you. So I said, okay, I'll go to college. And then I went to college and my interests changed. And
did you have law school and being an attorney in the back of your mind somewhere?
Never. I never thought I would be an attorney. I didn't know any attorneys growing up. I took like this criminal justice class in high school. And like, as part of it, we went to meet the judge. We went to like check out the courtroom and we watched a couple hearings, and the judge came out and like took off his robe and he was wearing jeans and a flannel shirt because it's Wyoming. And I just thought, hey, that's cool, but that's a world I'll never live in and never be involved in. That's for other kind of people. That's for a different caliber of person than me, I thought.
Yeah. Well, so you took cultural training from the Army. You were living in Jordan, and then a few years later down the line, you went to law school, became an attorney, and learned got different kind of cultural training, writing nasty meet and confer letters, taking hardline positions, and then by the time you pick up the phone, you're already entrenched in your position. What are some? Do you have any cultural connections between what you learned in the Army and the legal culture that I know a lot of judges would like to change, at least in terms of civil discovery and how it's become uncivil discovery?
Well, everything is combat, you know. You have to be prepared. Well, first of all, the Army taught me how to deal with every kind of personality there is. So any kind of opposing counsel that you get, whether it's a polite one or one that's fun to work with or one that's, a bit more work, you can navigate it. And so that is probably the biggest gift the Army gave me. But there's all the combat stuff. There's the, like know your enemy and know what, if you're going to flank them, like you got to know like what their plan is and how they're going to do it. So how they're going to mount their attack. So you got to know how they work and how they think. And so the best way is just to get to know as many people as possible and the legal landscape as it is and what firms do what and how those firms are. And then you can make your battle plan.
Yeah. What's a common mistake? Do you see any attorneys making mistakes that you think, these are common, they shouldn't be making these kinds of mistakes? And you kind of, if you had one thing to tell attorneys, but how to, what things they ought to stop doing or what things they ought to do instead?
Well, I deal in a lot of briefs, right? So I read a lot of briefs and I write as many as I read sometimes. But I say probably the biggest mistake is that people don't lay a factual foundation very well. They don't, the attorneys really don't somehow get that part of it. And every time I've talked to a judge about for advice on what they would like to see in briefs, they're always like, I don't know why what you want is so important. I don't understand the facts of the case. You think I do because you are so entrenched in it. as an attorney, and you know it, and you haven't taken the time to really lay that out for me and tell me why it's so important that I give you what you're asking for. And ever since the first judge told me that, I have really noticed that in briefs. There's a lot of conclusory statements of fact and not a lot of detail about why about why what you're asking for is important. And I really that sticks out to me a lot.
Yeah, well,
even though
there's a thought that every second I spend on talking about facts is a second that takes away from my argument.
Well, yeah, but you can't have your argument without the facts.
Right.
And
right.
You don't need 25 statements of law, and you don't need 25 cases to support your argument. You need 1 or 2 cases, and then you need a lot of facts. And people think that briefs are about the law, about arguing the law, but they're really about arguing the facts and why they apply and why the law should be applicable in the way you say based on these facts.
Yeah. No, I think that's good. I think it's like being faithful to the facts and giving comprehensive statement of facts is kind of like, it's like you got to pay your dues. It's like paying the meter. It's like putting coins in the slot machine. If you only put 1 nickel in, what's the most you can win by the time you pull your argument by pulling that lever? You have to put a lot of money in hopes of getting a big jackpot.
I like that analogy. That's funny.
Do you have a favorite part of your practice other than we appellate attorneys always say writing the briefs, but so
locking the doors, locking the doors and working on the brief,
turning off the phone. What I like the most is I love the writing. Nothing makes me feel more like a lawyer than those that time in the brief when it hasn't quite come together yet, but it's going to. You could see how the outline is shaped up, and you could see how the argument's going to flow. And that moment where it hasn't quite happened yet, and you still get the joy of being able to do that, that's one of my favorite times as a lawyer. But honestly, probably my favorite thing is that the way, with all the consulting I do and the ghostwriting that I do for attorneys, I really get to meet and work with a lot of interesting people, and to see how different firms practice and the way that they function differently. And then I could take or leave whatever I think is good or applicable to the way I want to write or do things. And just that insight into how other attorneys work and write and think is really invaluable. And it's really fun to collaborate with other people. It's not so fun when they're critiquing your brief, but
sure.
But it is really fun to, it's a good service to the client to get different minds going at it and to be collaborating in those different types of ways. So I think that's really fun.
You mentioned ghostwriting briefs. What kind of briefs do other attorneys hire you to ghostwrite, and why do they decide to hire you to ghostwrite their briefs rather than just write it themselves?
Well, if you're a busy trial attorney and you're managing a calendar between depositions and court appearances and mediations and arguments with adjusters and whatever you've got to do, that doesn't leave you time to sit down for 30 to 40 hours and write a summary judgment opposition. And even though you have a long time for a summary judgment opposition, from the time you get it, you got to spend a lot of that time doing the discovery that you need to oppose it, or gathering the documents, or there's not a lot of time for sitting down to write lengthy briefs. And so the main thing I get asked to write is summary judgment oppositions or summary adjudication motions. That's probably my number one. That's 70% of what I do, probably. And I do, other stuff like demurs in anticipation of, well, if they're demurring on this topic now, then that's going to be a summary judgment in the future anyway, right? Probably. And then also the post-trial motions and appellate briefs. So those are the main things I do.
With all that writing you do, what do you think your clients or the trial lawyers you work with or your opponents would say is unique about your writing or about your legal practice?
Well, I'm not sure that there are contract writers out there that do writing or research projects for attorneys. I don't know that there are very many practices out there that do the level and the volume of ghostwriting that we do. And so I think that's unique. I have a team of clerks and contract attorneys also that help me with my volume of projects. I'm always the finisher, the one who comes in and puts my personality and my stamp on it. But yeah, so that's a little bit unique. I don't really think that there's that many firms out there that do that. And, you know, I have a fairly distinct narrative voice. It's a little conversational. It's a little, you know, referency.
Yeah.
And so that's probably what people know about the briefs that I write for them sometimes. And sometimes people want a much more formal brief than I normally write. And some people are great with it. You know, I've got the blue hair. I'm a little bit funky. I'm a little quirky. And that personality kind of comes through in my writing. But, you know, the people that hire me over and over again seem to be fine with it. So, and I often get compliments on the briefs from judges or from courts too. So, or somebody will come back from the hearing and say, the judge made a comment about your brief. Like, if I could, I would put like memes or GIFs in briefs sometimes, you know, just like it, sometimes you could just make a really good point with it. And I don't think that the practice of law is quite evolved to that, but.
Yeah. Well, speaking of briefs and post-trial briefs, let's talk about the brief that we're here to talk about today, the one you drafted in the Victory Bell case, Garcia versus Quraishi, as we talked about at the top. This is the case where the defense attorney had made some comments that were captured on video that perhaps he was not aware of at the time, indicating that the reason he thought that he won the case is because he was able to convince the jury that other people that there maybe was some negligence, but that other people were responsible for it. And Brooke, I mentioned that there were some attorneys who were kind of scoffing at the idea that that could be grounds for granting a new trial motion, because, you know, this didn't happen in court. It didn't happen. It wasn't perpetrated by any of the parties. It wasn't committed in the presence of the jurors. So how could it be an irregularity at trial? So tell us a little bit about that motion that you drafted. What was it? What were the arguments that persuaded the judge that, yeah, this warrants a new trial?
Well, there are a few of them, and that language that you quoted is going to be really important. So I'll explain. It's true that a lawyer bragging about a victory at court is not new evidence. It's not something that really is going to generally have an impact on something at trial or the outcome of a trial. It's true. And if we chastise every trial attorney that like bragged about a victory he had or she had, like, we would be chastising a lot of attorneys, right? Everybody gets to brag. And I think there are ways to do it in ways that are less appropriate, of course, but the bragging is not the problem. The problem is more the language he used and how it affected issues at trial. So we made several arguments about irregularities at trial. The first was that, and this is the most important one, I think, and it actually has not much to do at all with the video, the Victory Bell video. But that defense attorney asked at the beginning of trial, he said, I have this prepaid arbitration coming up in a few weeks, and I can't cancel it. If I cancel it, I lose a huge deposit, like a $30,000 deposit or something. So I need to be able to be done for that arbitration. And the court was like, well, I'm not going to continue the trial. So let's try to get this done, but we'll figure that out. We'll cross that bridge when we get to it, basically. And the plaintiff's counsel was like, Your Honor, I could hopefully be done, but like, whatever. I don't want to have a big break in the middle of trial or something for somebody else's arbitration. And so he voiced his objection. And then, of course, it came time for the arbitration to happen, and trial was not done. So they took a 19-day break in trial so he could go do an arbitration in another case. And they came back for 1 day of testimony of 2 witnesses and then closing arguments. And so that was an irregularity that we thought was really significant, because by that time, even if they get the evidence binders and everything. And the jury has forgotten the demeanor of witnesses. They've forgotten exactly whether or not they liked certain experts. They've forgotten exactly what those experts testified to. And it's a medical malpractice case, so the expert testimony is really important. And so that was a big irregularity of proceedings that I thought on its own, without anything else, almost warrants a new trial in itself. The other small irregularity was that one of the jurors had a history of working in the insurance industry that was not disclosed at the outset of trial, despite questions that called for that disclosure. And that's a big deal. In that juror became the foreperson as well.
Oh.
So that kind of was something that maybe on its own is not quite enough, but when you start to bundle everything together, it all kind of adds up. And then the other big thing was that the plaintiffs did a motion in limine to prevent an empty chair kind of argument or evidence from the defendant. And the defendant testified or said to the judge in the hearing, I'm not putting on evidence of an empty chair. I'm not going to be blaming anybody else for this. My case is that what my client did is not medical negligence. That's my case. And then several times during trial, he brought up an argument in closing. He brought up an argument in questioning witnesses like, well, at the time of his death, the decedent was under the care of a lot of different doctors, but the plaintiff only brought in my client, which was untrue because there were multiple doctors originally sued that were let out on summary judgment, or different things happened along the way. And so he, in essence, did make an empty chair argument. And then that language that you quoted in his video at the end, he said, well, this doctor was probably, or the decedent was probably negligently killed. But we made it look like other people did it, which to the court confirmed that he was trying to make an empty chair argument.
Yeah.
Which affects the arguments he made, which was supported by the arguments he made at trial, and in violation of his promise to the court not to make such an argument. So I think that was really the court's biggest bone to pick with everything, was that that was not an ideal way to act. And then finally, he made some comments in the closing arguments that were super inflammatory about the plaintiff decedent and his family. They are Hispanic, and the plaintiff's attorney is Hispanic, and like the whole plaintiff's counsel, the team, they were all Hispanic. And he made some arguments in trial about, which he says were about the personal injury, and he called it the personal injury industrial machine. He called it in trial. And then he said, "Welcome to America," while pointing to the Latino plaintiff's table. And we made some arguments that was really inflammatory and not great. And then we also found out that we knew going in that there was a very short deliberation by the jurors. It was less than a half hour of deliberations. So that on its own tells the court that they were not really considering evidence. They were going on emotion. And right off the tail of that really inflammatory, emotional closing statement, the court said it's possible, or, that influenced the jury as well. So like, that was just it was kind of a list of things that made it an irregular trial. But that
interesting. The headline doesn't tell at all that it wasn't just the victory bell or the bragging or the posting of it on social media and all that, but there was a lot of things that led up to that admission, that statement that he had pulled a fast one on the jury.
But I will also say that the influence that video had on the judge's decision is that this case was in the media. This case was getting scrutiny. There were reporters at this hearing. There was his ruling was going to be analyzed. And so I think that regardless, I think this judge is a great judge anyways. And he's more open than some to considering that he might have made a mistaken ruling, or that he might have allowed irregularities in his courtroom during the trial. I think he's more open than some would be, but that outside media scrutiny is going to make a judge pay a little bit more attention, or more carefully consider how it's going to look if he doesn't grant a new trial, or what the law is. So I think that it did help in that regard. It did have an effect in that regard as well.
No, I do think that's interesting that how it linked up this statement by the defense attorney at the victory bell, that a guy was probably negligently killed, but we kind of made it look like other people did it. So that really circled back to this motion in limine ruling, or was it an opposite? Let's see. So what was the trial judge's ruling on the motion in limine? So the motion in limine was by the plaintiff to prevent the defense from putting on an empty chair argument. Now, just for listeners who don't practice in personal injury law, an empty chair argument is where the defense will defend against a personal injury claim by making it look like some third party did it. The defense wasn't responsible for it. It was some third party. It was the person in the empty chair. He's not here today to defend himself. And so McKenna, the attorney, said, no, we're not. Don't worry, Your Honor, we're not making an empty chair argument. But then, lo and behold, after the verdict comes in, this video surfaces and we won the case by making this excellent empty chair argument. And so did it take some reminding on your part to remind the judge about, remember this motion in limine, or was the judge already keenly aware that what had been pulled in this case?
Well, I don't know the answer to that. I don't know what he knew, but I certainly did that. That was part of my paying the factual dues, that I had to say, look, here, this motion in limine was filed on this date. This motion argued this X, Y, and Z. And then if we go to the trial transcript from that hearing, here's what words were said. And here's the, quote from McKenna at that time. And at that time, the court declined to make a ruling one way or the other on that motion, because based on the promise from McKenna, he didn't think it was going to be an issue. But if something came up in trial, he reserved the right, kind of like, if something comes up in trial, the plaintiff is free to object, and we can readdress this later if that does become a factor. And then pointing to the trial transcript places where it did come up later and there was an objection. And so that's laying the factual foundation. You've got to go all the way back and show every document and every quote from the trial transcript that tells that story.
Yeah. And well, that's interesting. That does make a difference. As I mentioned, I was one of the scoffers at the beginning when I thought, this is just a video. It's he's just thumping his chest. It doesn't really make a difference in what actually happened at trial. It doesn't show an irregularity at trial. But with that context, I think that may be persuasive.
Yeah, I mean, the video was unprofessional. It was, I got to sock 3 lawyers in the face, he says, and and then he issued an apology video afterwards, which was a non-apology apology video.
Oh, I didn't know that.
Yeah. And it was basically like I'm sorry that I got recorded, and I didn't know I was being recorded, and I'm sorry if I hurt anybody, kind of apology.
It's the Homer Simpson apology. I'm truly sorry. I genuinely thought you would never find out.
Yeah, and we've all speculated, like, I wonder what happened to the person that recorded and posted that video, and who knows. But there is some stuff going on now that the judge granted the new trial, and that ruling has now been appealed, and that's an appealable order. So a direct appeal order. So we get to go through it's not just a writ. We got to wait through the entire appeals process now to make sure that the Court of Appeals agrees that ruling by the trial court was, not an abuse of discretion. Right. And once that happens, which I fully expect it to happen, then we can have a new trial. And they've brought in now because the attention this case got, they've got in trial attorneys that are like really experienced in med mal cases, and they're going to come in and try the case. There's going to be it's going to be a lot more people on deck for the new trial when it happens.
Oh, sure.
And
hopefully no 19-day pauses in the middle of trial this time.
Yeah, that will not happen, I'm sure. Nobody's going to let that happen.
And I suspect plaintiff's counsel will have you there as embedded counsel to watch just to make sure there's no appellate issues for the second appeal.
That would be great. Yeah.
Interesting. I didn't know that an order granting a new trial is directly a directly appealable order. Interesting. Or maybe I knew that a million years ago for the certification exam.
That's also a thing I learned with this. I was like, what do you mean they filed a full appeal on that one ruling? But they did, and I looked it up, and it's true.
Interesting.
Yeah.
So, Brooke, you need to send us a link to that apology video, because we do show notes and we put links to all our articles and things. And I'd love to, for our listeners to be able to see that video.
I will try. I know it was posted as just an Instagram story, so it was available, but I have a transcript of it, so I can send the transcript to you if you'd like.
And Brooke, based on this experience and your other experience ghostwriting post-trial motions, do you have any other post-trial motion and new trial motions strategies or tips for our listeners? Any common mistakes or pitfalls or positive tips of things that you should do to get better results in a post-trial motion?
Well, I think your biggest pitfall is make sure that the hearing date for your new trial motion is within 60 days of the verdict of entry of judgment, or I think it's entry of judgment. You've got to have that hearing within 60 days. And there are very specific filing deadlines associated with it. And if you mess up any of them, it's fatal to your motion. And in some cases, if you're trying to get a new trial based on things like the jury didn't award enough money or a couple other things, you have to do a motion for a new trial if you want to do an appeal on it. So most things you argue on appeal, you don't necessarily need a motion for new trial, but some things you absolutely do. So those timing issues are really important. The other thing I'd say is motions for new trial, that though they're not often granted, they're a great way to attach things to the record that might not have otherwise gotten on the record. Attorney declarations and documents that may not be lodged at court, you can now get them there. But here's my big tip for when I'm starting out and I don't really know. You've got what, a 15-day trial. That's 15 days of transcripts to go through, all the evidence, all the whatever, all the testimony, all the documents. How are you going to make sense of what's an irregularity and what's not? And I always start with the minute orders from court on those trial days. Those minute orders, they lay out what happened on every single day, which witnesses were there, what hearings were held for which motions, or which, if there was a thing that happened outside the presence of the jury, or those are going to be the flags that take you to the highlight portions of the trial and get you to where you might start finding those irregularities quicker. I mean, always when I get it, I ask the trial attorney what happened, what do you think went wrong, or what do you think the grounds are? But as the person writing the motion for new trial, you've got to go through it yourself and put on your own thinking cap and find it. And I think those minute orders are gold for giving you an outline of the trial and where to look for what information you might need. Because
the first thing the trial lawyer usually tells you is the judge is dumb, or two, the witnesses all lied. So you got to get past those first two issues.
Or the jurors screwed me over.
Right.
Yeah.
And sometimes the cold, dry record doesn't read as scandalously as you were originally led to believe by the trial counsel, who will talk in very vibrant tones about the gross and obvious irregularity that occurred. And then when you read the minute order and you read the transcript, you think, well, I see what he's talking about here, but it really doesn't leap off the page. I'm going to need a little bit more to really frame this, or maybe we drop it as an irregularity, because I don't know that rises to the level. So those can be tough. Through the loser's eyes, everything looks like an irregularity.
Well, trial is a performance, right? If you're a trial attorney, it's a performance of sort. You're projecting and you have your personality out there before the trial, and personality is not a thing that comes through on the page very often. And things that sound great when you say them out loud, you read them on the paper and they don't sound as great. And some of the arguments in this particular trial, the Garcia trial, I had a hard time following logic just reading what was said, or in the closing arguments from both sides, kind of. But I imagine that if you heard it in person, it would have been a lot more dynamic and a lot more interesting to listen to, and might have been easier to follow. So yeah, that is a big challenge.
Yeah, no, that's true. But as the appellate attorney who is coming in after the trial, you didn't have the advantage of the front row seat and hearing the modulation and tone and everything during the trial. And the other person who's not going to have had that front row experience is the appellate bench, the appellate panel. So you're going to have to make your arguments about irregularity from the cold, dry record, and not reports of what happened as it looked and sounded like from the front row. That's
a really good reason why it's good to have somebody else write the motion for new trial, somebody other than the trial team or the trial attorney, because they're going to have their passions are also inflamed, right? They were there at trial. They were entrenched in it. It became their life for several weeks while the trial was happening, and they feel strongly about everything. And it's harder to be objective when you feel really slighted or really like you were treated unfairly. And if you are someone that's coming in from the out, you could be a little more analytical and a little less inflamed, even if your bias, like mine, is to always root for the plaintiff, or, like you have a particular thing that you generally go towards. It's easier to be analytical when it wasn't something that was part of my life for a long time. And I don't personally know those plaintiffs. And so I can sympathize, but I don't feel that pain the same way. And so it is a good reason and that you're right. The appellate justices, they don't know that either. They don't see it or feel it. And it's an abstract thing to them. And so it is a good reason to have someone else come in and at least look at or give advice on, or, write the whole motion.
Well, thank you for sharing about the Garcia case. I think it's before we get to one other topic, I want to ask you if there are any other juicy details from that case that we haven't covered.
Well, the juicy stuff is, so that appeal is happening on the ruling for the motion for new trial. In the meantime, Dr. Qureshi, he has new counsel, and there is a legal malpractice lawsuit as well as a defamation lawsuit based on that video as well.
A defamation lawsuit. What are if you don't mind, what are the allegations in that defamation lawsuit, and when will the anti-slap motion be filed?
The person in the empty chair come forward?
No, that the defamation is my client is a negligent doctor. That's what he's saying. He's saying his attorney called him negligent and told the world that he is a negligent doctor.
Interesting. Okay.
So who knows if that's a viable claim or not, but it's juicy.
Yeah. Interesting.
I don't know the exact allegations or like how it's all playing out exactly, but that's the juice, the hot goss.
Your motion came about around the same time that my office was moving, and we were going into new office space with tenant improvements, and we were trying to decide whether we should install a victory bell or not in the new office. And we decided maybe we should, for those instances where in the Orange County, the appellate courts in the 4th Appellate District in Orange County, when we got a brief filed successfully with proper bookmarking and all that, we thought about having a bell, to celebrate whenever we got it filed on the first time.
I'm so glad that I'm not the only person that always gets their documents rejected.
It happens.
So
I've had attorneys come to me in desperation and says, I've prepared the brief, it's finalized, I did the proof of service and everything, but I can't get it filed. I've tried 3 times.
Yeah.
Oh, the worst is when that appendix is over 25 megabytes.
Right.
Oh, no.
And it's like filing time is right now.
Nothing worse than that. All right.
So I will say, I don't think that the victory bell is a bad thing. I think it's great. I know a few different plaintiff law firms that have it, and it's great to win a victory bell, but maybe just consider whether you post that on social media and whether ringing the victory bell is going to be perceived as celebrating the death of somebody. So
yeah, that's a fair point.
Yeah,
that's a fair point.
Yeah, we gotta retain our humanity here. Despite we love getting a win, but sometimes our profession, involves some morbid subjects, and we have to show some due gravity for the human element involved.
And I also just want to say, like, I'm not here to just bash on this defense attorney. Like, he made a mistake. I know, like, he's a successful, like, well-loved trial attorney that's been practicing for a lot of years. And I don't think this one thing should define him. I think it is a mistake. I think it would be nice if he owned up to it a little bit more, but I also understand there are lawsuits and situations that would have an effect on. So I think it's good for us all to take stock and, like you said, retain our humanity. So.
Well, with that, Brooke, let's have a mini book club here. You are the host of a podcast involving attorneys talking about books and movies. The podcast is called Lawterature, a play on the word literature. Brooke, tell us what you've learned from hosting the Lawterature podcast, talking with attorneys about books and movies. What are some nuggets you've learned from talking with attorneys about literature?
Well, the thing, my whole thesis for the podcast is that no matter what book you're reading, law is involved. Whether the subject of the book is a criminal case or a trial situation or not, there's law involved, and law touches every part of everybody's lives. As attorneys, we're storytellers, and the better we can get acquainted with and know about stories and how other stories are told, the better storytellers we become. So that's my link between literature and lawyering. But you just get to know a lot about a person by the book that they choose or the story that they choose to discuss, because on literature, book is defined as anything that tells a story, right? It's got to be a story. It could be even a nonfiction book. It doesn't have to be fiction, but it could be nonfiction. It could be fiction. It could be a movie. It could be, I had one guest who chose a song, and it's a storytelling song, like a song that told a story. So we were able to apply the law to that story. But wherever you look, there's law, there's legal issues. And so I like to highlight the attorney for a part of the episode, like you've done with me today, tell their story about their lives and their practice and things like that. And then we do a book review. We go through the facts of the story. The statement of facts is our plot, right? And then
the book.
Yeah. And then, yeah, exactly. That's what we do. And we treat it as if it's a law school exam. We issue spot it. Are there criminal issues? Are there estate planning issues? Are there torts? Are there, you could find anything in almost every book. So sure. I'm dying for somebody to, nobody will take me up on this, but I'm dying for somebody to do the 50 Shades of Grey book with me and analyze that, they have a contract in that book. Like, that's like, here's what's allowed in this relationship that we're setting up. And
I nominate Tim. I think Tim would be perfect for that.
Safe word.
Yeah. So I think that it's mostly just fun and a way to get to know more attorneys and be forced to read things that I might not otherwise read. So,
well, what's an example of a book or movie that you read or watched because you were hosting Lawterature that maybe you wouldn't otherwise have read or watched?
Well, the first one that comes to mind is Peace Like a River, and that's a book I'd heard of, but I never would have thought to read it, and it had an enormous impact on me emotionally, and I never would have found that book if it hadn't been for that podcast. And the other one that comes to mind is I had my brother-in-law on, and he's not a lawyer, but he had me read a book that was it was a teen drama, like a teen high school drama kind of book, but it was a romance, and it was a gay couple, a homosexual male couple, and it was not a thing that I would have normally read. It's just not like what I'm interested in. Like, like that's not the thing that is going to be my first thing, but it also had a really big impact on me, that book. And a YA novel is not something that I'm normally going to feel like is going to have a big impact on me. But
right.
Those two novels are probably the most impactful. But I mean, we've done everything from To Kill a Mockingbird to the song that we did was the Gold Digger song. I did it with a family law attorney who we talked about prenups, and everybody's got some sort of take on things that's really interesting. So,
and I saw that, of course, you've covered My Cousin Vinny, one of the greats.
Yeah, we did Crime and Punishment, and
Have you covered the Dresden Files yet on your podcast?
No, that's a great one.
I'm ready to come on when you're ready to talk about the Dresden Files. That's my favorite series.
I'm making a note of that.
Lots
my
of
friend,
law.
Yes, my friend and me are going to do The People versus Larry Flint soon.
Oh, okay, great.
So there's the court case ones are obvious, but I like the idea of pulling out one that's not obvious and finding some fun law to discuss.
Yeah. Well, just to tie your podcast about books and movies back to brief writing, you mentioned you like to you make your writing referency. Does that include references to pop culture, books, movies, and things?
Yeah, I try to do that if it can be done in an impactful way. I'm not doing it just for the sake of doing it, but in a foreseeability argument, once I really strongly wanted to put the meme from Dumb and Dumber where he's like, "You're saying there's a chance," Yeah. So instead I just said, Lloyd Christmas would agree with me. So I just made a quick reference to it, but I do that occasionally. Look, writing is sometimes very tedious, and sometimes, especially if I'm up against a deadline and I'm like trying to stay up late, I will say, okay, my job for the next 2 hours is to throw as many Harry Potter references or as many Back to the Future references as possible into this brief. And that will keep me engaged with what I'm doing. And then, you go back and take it all out or most of it out later. But just to keep it fun.
Yeah. All right. Jeff, I think it's that time in the episode.
All right. It is the time for our patented, copyrighted segment of our show that answers the most pressing questions that vex appellate nerds around the world. The dreaded lightning round. We're looking for short responses, 1 sentence or less. And Tim is the number one violator of that rule when he pipes in. Here we go. Question number 1, font preference. Century School Book, Garamond, or something else?
Oh, Tim's going to be so mad, but I am a Times New Roman girl.
Oh, I'm so disappointed.
We got
even in appellate briefs?
We got to pre-screen our guests a little better than this. Times New Roman. Okay.
You're not the first, Brooke.
2 spaces or 1 after a period?
1.
All right. Correct. Superior Court, capitalized or not capitalized when you're writing an appellate brief, the phrase Superior Court?
Capitalized.
All right.
It's not literally superior. If it was literally superior, you would use lowercase.
Well, you can't say inferior, so you just gotta show a little deference, especially if you got to be in front of that judge some other time.
That's right. So correct answer.
In the appellate court, we're talking about appellate briefs here. Your major argument headings: all caps, initial caps, or sentence case.
Oh, the big headings are all caps.
Yeah. Okay. And left justify or full justify for your text?
Full justify.
All right.
Full justify.
Wow. All right. And we already got the answer to this before the podcast started, but I'll ask anyway. After major headings in a brief, do you start the next section on a new page or you just continue immediately below?
Lawyer answer, it depends. Okay. If you're halfway through the page, start the new section on a new page. But if you've got, if you're early on in the page, like start it, do a couple line spaces, and then start it there.
All right. Other than your questionable font choices, you have survived the dreaded lightning round. Congratulations. Back to you, Tim.
All right, Brooke, thank you so much again for joining us. And that's going to wrap up this episode. We want to thank our sponsor once more, Case Text. Each week, we include links to the cases that we discuss, and we use Case Text. Listeners of the podcast can find a 25% lifetime discount available to them if they sign up at casetext.com/CALP.
And if you have suggestions for future episodes, please email us at info@calpodcast.com. And in our upcoming episodes, look for tips on how to lay the groundwork for an appeal when preparing for trial.
Thanks, and see you next time.
Thanks, you guys.
You have just listened to the California Appellate Podcast, a discussion of timely trial tips and the latest cases and news coming from the California Court of Appeal and the California Supreme Court. For more information about the cases discussed in today's episode, our hosts, and other episodes, visit the California Appellate Law Podcast website at calpodcast.com. That's calpodcast.com. Thanks to Jonathan Caro for our intro music. Thank you for listening, and please join us again.